Welcome back to UPC Insights, the go-to podcast for insights into the Unified Patent Court's proceedings. I'm George Walden, and today we continue our deep dive into the nuanced interactions between the UPC revocation actions and the EPO oppositions. Rejoining us are our esteemed experts, Rainer Beetz from Austria, Sam Giles from the UK, and Tilman Pfrang from Germany. All UPC representatives and seasoned patent attorneys in their own rights. And in this episode, we shift our focus to the practical side of these proceedings. How does the UPC handle the case with ongoing EPO oppositions? And what happens when decisions between the two bodies diverge? We explore real-world scenarios, discuss strategic decisions, and examine the impacts of conflicting outcomes on patent enforcement. So let's get started and navigate the complexities of these pivotal legal frameworks in action. Sam, let's start with you. I have learned last time the tradition in the UK is very similar to the situation at the UPC. Can you describe a scenario where the UPC revocation action and EPO opposition are ongoing simultaneously? And how do the UK courts typically handle such situations?
It's good to be back. So there was one case very recently. Obviously, with the UPC, there isn't a huge amount of case law just yet, but there was a revocation decision, I think just last week, related to EP 366-6797, and in particular between Amgen and Sanofi. And I think this was possibly the first revocation action ever filed at the UPC.
Wow.
And there was also an ongoing opposition. Now, because the EPO is extremely fast at dealing with all matters of opposition, I don't believe they've even reached a preliminary view yet from the opposition division, and yet we already have the decision of the UPC. So in that case, the patent has been revoked by the UPC, whilst we don't yet have a decision from the EPO, and we're not even particularly close. So you can see there the benefits in having a fast and efficient system, and we hope that the UPC maintains that, and hopefully the EPO learns something as well about how they could actually seek to expedite matters and have them seen and heard and then decided in a slightly more timely manner.
Sam, is there a possibility that the decisions made by the UK courts could diverge from those made by the EPO regarding the same patent? Or if so, what are the legal consequences of such divergences?
Yes, unfortunately, there can be quite a few instances where this kind of thing happens. So obviously in the UK, we have cases that run in parallel, where there is an ongoing opposition and an infringement and revocation action going through the UK courts. One particular case was Virgin Atlantic Airways versus Zodiac Seats, and this related to the aircraft seats being reclined for long-haul aircraft. Virgin Atlantic were the patentee, and Zodiac manufactured a seating unit called the Solar Eclipse. And effectively, this went through the High Court, and then went through the Court of Appeal in the UK. And at the Court of Appeal, it was decided that the patent was valid and it was infringed. And then at the same time, it was going through the opposition and the Boards of Appeal of the EPO. And some time afterwards, I think around 6 or 7 months after the Board of Appeal decision in the Court of Appeal decision in the UK, the Board of Appeal decision came through and amended the patent quite significantly, to the point where it was subsequently decided that there was no infringement based on the newly amended claims. So you could see there the divergence in that the two courts came to two differing views.
Right.
And it was partly because of this case that the UK Supreme Court directed the UK courts to consider whether stays should be more common in the UK, and hence the kind of balance of justice that I discussed in the last episode was reached. But there are plenty of other decisions that have happened even slightly more recently, where the EPO and the UK courts have come to different conclusions. For instance, in 2020, Neurim was the patentee, and its exclusive licensee Flynn were against Mylan, and actually with some rather comedic timing, On the 16th of December, the judgment came out saying that the patent was infringed and valid. And then on the 18th of December, the Board of Appeal revoked it.
Wow.
And then the UK courts had to go back and amend their order and change things quite substantially, because clearly that divergence is not allowable. When a patent is revoked by the Boards of Appeal, that's it. There's no, that revokes the UK portion of that European patent. So it doesn't really matter what the UK courts have said.
Okay.
They may have said that it was valid, but once that patent has been revoked by the Boards of Appeal, that patent no longer exists and has never existed. So it's a kind of a moot point.
Wow. Okay.
I find this very interesting, to be honest, because everyone, let's say, outside of the UK is a bit cautious how the UPC will deal with such situations. But I mean, in UK, you have a large history for such situations. So, I mean, if there is a problem, you should ask an expert of the UK, I would say. Yeah.
I mean, it's one of those where practice has evolved over time. Initially, there wasn't kind of a de facto stay, and now that is more common. But when you look at how slow the EPO has been, I think one of the reasons the UK courts are so, or have traditionally been slightly more reticent to accept stays, is that if you've had these two, if a patent grants and then on day one you file an infringement claim in the UK courts, and on day one the alleged infringer files a opposition at the EPO, that opposition could take a substantial amount of time. And it is in the interest of justice for there to be a resolution earlier, and getting a decision from a UK court or a German court or an Austrian court is quite likely to help the parties reach a settlement earlier, and so may actually lower costs and be in the interest of the balance of justice. So I think it really is determined partly on where we are in that timeline.
Absolutely, yeah.
Yeah, Rainer, considering that there are up to now relatively few UP decisions, and as far as I know, none concerning final revocation decisions that conflict with the parallel EPO decisions, would you expect the situation within the UPC to be comparable to that in the UK regarding potential divergencies from the EPO decisions? Or how do you anticipate such situations will be handled within the UPC?
Well, generally, I do expect quite a similar situation as we have it now in the UK. What we haven't got so far, as you pointed out, is a final decision by the UPC conflicting with parallel EPO decision. But what we do have since last week is a first instance decision. It comes from the Paris local division in a case. It's Dexcom against Abbott, C230, 2023. And in this case, we had parallel opposition proceedings and a counterclaim for revocation with the Paris local division. The European opposition division upheld the patent in suit in first instance, and later on, now in this UPC proceedings, the Paris local division revoked the patent in first instance, contrary to the decision of the EPO, which means that now the patent is revoked for there's now 17 member states of the Unified Patent Court system, whereas the UPC cannot revoke patents for the other EPC member states, which are not within the system. So there is still a bunch, namely 22 other member states where the patent is still in force. So there's also this territorial difference between the UPC and the EPO.
Sounds crazy.
Yeah, it is. It's quite a complicated system. But what we've seen so far is that I would say that the UPC takes its own view and is prepared to issue conflicting decisions with EPO decisions. I think not only with first instance EPO decisions, but also with conflicting decisions with the boards of appeal. I mean, in the end, at least for the 17 member states, the decision which is more restrictive, which is more limiting or even completely revoking the patent, will take precedence over the other decision, which kept the patent in a larger extent or as granted.
So then, Tilman, that brings me to you. Based on your daily practice at the UPC, can you share any clues on how the court will handle cases involving potential conflicts with EPO decisions? Now, that would be interesting.
Yeah, I guess so. I mean, it's probably again about stay of proceedings and whether or not the court should or will stay the proceedings. From what we have observed in one of our UPC appeal proceedings, actually, where we have a final order, it's the case number is COA 22 out of 2024. The UPC, or at least the Court of Appeal, but now only the first instance, is not afraid of conflicting decisions.
Mm-hmm.
I mean, in our case, I have to read it actually. In our case, the Court of Appeal stated in a headnote of the decision, I quote, "Firstly, decisions in which the UPC and EPO issued different rulings on the revocation of a European patent are not irreconcilable."
Okay.
So they see a solution for that problem. Where one body upholds the patent and the other revokes it, the latter decision will prevail. What do they mean? They mean that if, for example, the UPC says, well, everything is fine with the patent and the EPO revokes it, the patent is revoked, at least for the relevant territory. Or actually, if the EPO revokes it, it's usually revoked in its entirety. And the Court of Appeal goes on. Secondly, the interest of harmonizing decisions on the validity of a European patent can be promoted by ensuring that the body that decides last can take the decision of the body that decides first into account in its decision. So
Okay.
again, very practical. I mean, they say if there is a time delay between the decisions, the one instance or the one court body can take into consideration what the other body has said. So again, I think this is an example of, yeah, well, the practical approach of the UPC, and also an example of what we've seen so far, that the UPC is really willing to go through to decide on the issues, so that they seem to use their discretion regarding stay of proceedings, at least in that case, rather reluctantly.
Okay. Tilman, one more question for you. Have you ever been disappointed by the rulings by some of the EPO or opposition things? Because it seems like everything is so open here. How do you, I mean, can you trust it? Can you, if you have a good case and it gets thrown out, or?
That's actually a good question, George. I mean, in the end, of course, you are not always satisfied with a decision of the EPO, for example. And therefore, it's a very good thing to have this court, the UPC. There will also be decisions where we are not satisfied with, but that you have a second body, a second authority, which may more lean towards your arguments. Maybe you have good arguments, but the body deciding on it, the EPO in that case, or the opposition division, is not willing to follow it. And then you can, in parallel, and this is a good thing, also bring your or similar arguments at the UPC and hope that they will understand.
Okay, good. Given the complexities you've described, Tilman, it seems like the issue of whether to stay proceedings could be crucial in managing cases with parallel EPO actions. So I'm going to bring this question for Sam. Can you explain, under the circumstances, the UPC might decide to stay its proceedings, and what factors influence such decisions? Is there any case law?
So I think we've got two kind of guiding cases on this. So we've got Carrier Corp versus Bitzer Electronic, and the head note said, words to the effect that the UPC will not stay proceedings generally because they want to keep to the strict one-year timetable that expedite the date on which the final decision is reached. And then in another decision, the Estellas Institute against Hilos, in there, they said that where an EPO decision is expected soon, and there was a concrete date set for that decision, then a stay may well be utilised. So I think you can see there that that's not a million miles away from the UK in terms of where a decision is expected soon, a stay is reasonable, and where a decision may be substantially further away, and generally they won't. I think if anything, the UPC is even less likely to grant a stay than the UK courts in cases where there isn't an imminent decision expected from an EPO opposition. But I mean, going back to briefly to what Tilman said, I think it is really interesting because you've got a lot of these cases, you've got two sides, and it's a finely balanced decision, and those parties are only going to bring their case all the way to the court, all the way to the Board of Appeal, if they really believe in it, because they're spending a lot of time and money, and they're obviously going to have conflicting views. So one of those parties always has to be the eventual loser. So it's only really in these quite fine decisions that we're going to get these multiple judgments anyway. So it is to be expected that judges are going to fall one side of the line on one case and the other side of the line on the others. So I think we can expect, it not to be unusual to get conflicting decisions between bodies.
Okay. It brings me to a question. It seems like kind of like divorce court judges, the ones who with matrimony with a couple that they're fighting between, and the judge tries to be lenient on both sides. Would you equate that to what you're going through with the UPC and EPO situations, or not so drastic? Or is it the winner takes it all, like ABBA, just like, how does that apply?
Well, I mean, in terms of complete revocation, it's definitely the winner takes it all.
Okay.
If the patent gets revoked, there's no kind of two ways about it. And I mean, the same with infringement, really. I mean, if the patent is held to be partially valid but not infringed, I mean, you've still lost, haven't you?
Yeah.
I don't think that they will be trying to settle it up like that. I would hope that both the Opposition Division, Boards of Appeal of the EPO, the UPC First Instance and UPC Court of Appeal would all look at the facts and of the case and try and determine to the best of their ability whether the patents are valid or not, and not spend too much time trying to placate the parties. And I think, based on listening to previous episodes of this, I think that Tilman said that the way that the court was set up would probably help with that kind of thing.
Right. Excellent. Rainer, if a party is interested in accelerating the resolution of the case, what strategies or mechanisms are available to speed up proceedings at the UPC and or the EPO?
Well, at the UPC, there are very limited options to speed up proceedings. However, the proceedings at the UPC are generally extremely efficient and quickly. So we've seen now, just a year after the commencement of the court, that the first instance decisions were issued. So what was the time frame which was set up, the rules of procedure, 1 year first instance, they really stick to this. So it's a quick procedure. There's basically, from my point of view, even no need to speed up proceedings at the UPC. At the EPO, there is an option. You can request accelerated proceedings, especially in case parallel court actions are running. The EPO will speed up these proceedings, these opposition proceedings. However, I doubt that such an acceleration of the EPO opposition proceedings will have any impact on the question of a stay of a parallel UPC revocation action. So there have been decisions from the UPC where the question was, well, what is a rapid decision? Is it a rapid decision by the EPO in first instance or in second instance? And the UPC said, well, it's not specified in the rules of procedure whether it's a first or second instance, a final decision. But the likely scenario is that in EPO opposition proceedings, both parties will appeal, and therefore will take a few years until we have a final decision. And therefore, this is the time frame I have to consider when to decide whether there is a rapid decision. So even if I would have a rapid decision in first instance at the EPO, it might still take another few years until you have a final decision. And therefore, I do not believe that speeding up EPO opposition proceedings, which is possible, will really have an impact on parallel revocation proceedings in the UPC.
Wow. Do you agree, Tilman?
I absolutely agree. I mean, on the other hand, what I also find amazing actually is how the EPO reacted to the competition of the UPC, so-called competition, and that they actually established this even more streamlined procedure very quickly, and that now they promise, I don't think there is a case yet, but they promise to have a first instance decision after 7 months from expiry of the 9 months deadline. This is always the problem for the opposition division or the EPO. They can only start after expiration of the 9 months deadline, whereas the UPC can start at day 1 of the grant of the patent. So I agree with Rainer that probably this will not have a huge impact alone for that reason, because UPC has, in at least in the extreme case, 9 months advance. Well, yeah, totally agree.
So now that I have all that, I think our listeners can probably get a good view of what's going on or what's to be happening in the future. And that's going to wrap it up for us today. This UPC revocation and EPO opposition digging deeper part 2. I would like to thank you, our listeners, and our distinguished panel of UPC representatives. First of all, the honorary Rainer Beetz from Austria, Sam Giles from the United Kingdom, and the Honorable Tilman Pfrang from Germany. All of us at the UPC Insights are really happy that you all took the time out from your busy schedules to join us today. Thank you guys for joining us on the podcast today.
Thank you, George.
Thanks a lot.
Thank
We
you.
have a lot of great UPC Insight content from past shows that are more relevant and exciting than ever, and we urge you to check them out on our YouTube channel or our website at meissnerbolter.de or meissnerbolter.com. If you have any questions or any UPC Insight topics that you would like to talk about and explore, feel free to contact us. And until then, see you next time on UPC.